After understanding the primary evidence, let us move towards secondary evidence, which is actually hidden in section 63 of Indian Evidence Act. Secondary evidence means, and it includes several following types of documents which we are going to discuss hereinafter. First of all, certified copies given under the provisions hereinafter contained. That means if any certified copy is produced by one or the other government department or authorized officers, those copies which are certified by the concerned officers are considered to be secondary copies of the original document, that can become secondary evidence of the original document. Secondly, copies made from the original by mechanical process, which is themselves ensure the accuracy of the copy and copies compared with such copies. That means we can generally take the copies which have been scanned and taken printed, or sometimes we can even go for Xerox copies. These copies are actually produced from original document to the Xerox copies or photocopies. They are coming from a mechanical process. So because of the mechanical process, the accuracy of the contents of documents from the original to the Xerox is compared and it is perfect. That means the accuracy of the content of the document is certified. Because of the quality of Xerox, today we can have the accuracy with regard to contents of a original document and a copy. That's why Xerox copies are also secondary evidence of the original. Next comes copies made from are compared with the original. In earlier days, we did not have Xerox machines. That time, even the court certified copies were given in handwritten format. Once it is written in the handwritten format and certified by the court authorities, that comes under the category of copies made from and compared with the original. That's why any copy which is made from and compared with the original, that is also becoming a secondary evidence of the original document. Then comes counterparts of the documents as against the parties who did not execute them. That means if there are two counterparts of a document, one counterpart is executed by one party, another counterpart is executed by another party. If any document has to be proved which is a counterpart of another document, if it is not executed by the party, then the party who has not executed it, he can use that as a secondary evidence of the another counterpart of the document. The last one is oral accounts of the contents of a document given by some person who has himself seen it. Means any person who has personally seen the document, if he comes before the court and gives the oral form of evidence, his oral form of evidence is also considered as secondary evidence of the original document. This is how section 63 clearly explains what is actually the secondary evidence means. Illustration, if we see, a photograph of an original is secondary evidence of its contents, though the two have not been compared. If it is proved that the thing photographed was original, that is enough to say that this photograph is the secondary evidence of the original document. Like this, so many things have been explained in section 63. If we see one of the reported cases in AIR 1999, Punjab and Haryana, page number 21, Shobha Rani versus Ravi Kumar. In this case, it is held that admissibility application moved for permission to lead secondary evidence based on ground of loss of the document. The presence of document proved from the fact pleaded, allowing the secondary evidence is not illegal. That means in this case it is held that when the original document is not there in the authority of the person who needs to prove the contents of original document, he can even file an application for seeking permission of the court for production of a secondary copy. In case Mohan versus Sandhya Mohan, AIR 1993, Madras 59, tape recorded statements are admissible in evidence as secondary evidence. That means it was held in this case that even the tape recorded statements of the original document are considered to be as secondary evidence in the court of law. Like this, several important judgments we have seen wherein the secondary evidence is permitted in the absence of the original or primary document. Section 64 deals with proof of documents by primary evidence. Proof of documents by primary evidence means the documents must be proved by primary evidence. That's the basic rule, except in the cases hereinafter mentioned. Means the general rule and the basic rule is that all the documents and its contents must have to be proved before the court of law by producing the original document. That means primary evidence of the original document, except in the cases which have been accepted or which have been exempted in the following sections. From section 65 to almost section 73, we will discuss which are those circumstances in which the secondary evidence of a primary document will be permitted in the court of law. Thank you. After